Not just in this, I have been served with the reply by other side. In this, I have been served by reply by other side. May request for a week's accommodation to put in rejoinder. The short issue is whether the only defense that they have taken is whether writ petition is maintainable or not. I am directly covered by judgment of Honorable Supreme Court. I just want to place that on record.
Why do you want to require rejoinder for that?
Then I may proceed, Lordships. If I may just, in that case, if I may give the facts of the case.
Yes.
Please, my lord. Lordships, petitioner was awarded a contract for construction of minor earthworks and brick lining structures.
For release of the amount.
I satisfy my lords by way of two judgments of Honorable Supreme Court, direct judgments which says that even relief, monetary relief can be awarded in the writ petition. One is of 2022. But before going to that, if I may just draw my lord's attention to the facts of the case, the scope of issue is also limited. If I can take 5 minutes on that. In execution of work, therefore, in our cases, the delay was attributable to them. Our cases, the delay was attributable to them. I'll straight away jump to 2006, wherein they took undertaking from me for the purpose of execution of work on the ground that I'll not, if they will not pay me.
2006, nothing is stated in your synopsis.
No, I have stated, Lordships.
Come to your synopsis B.
Yes, Lordships.
12/8/2005, 1/12/2005, then you go to 15/1/2007.
Please, my lords, if Lordships, but in the memo of petition, I have stated,
Either you stick on to this or to that.
I stick to memo of petition because that is.
Then you will dismiss it on the ground that your synopsis is not proper.
Lordships may not do that.
What is that, sir? Why do you give synopsis? Is it for eyewash? Your synopsis should contain the concise statement of your facts.
I bow down.
Is it not so?
I bow down.
Then,
Lordships, in that case, what I can do is I can replace this synopsis within.
tell us again. This will go again for another 6.
Please, my lords. Therefore, if my lords may have page number 136.
Tell us the fact. Then after the tender was withdrawn,
yes,
and they decided to give the remaining work to others.
No, Lordships. Yes. So if my lords may have page number 136, 138A for a moment.
Tell us the facts.
Yes. They awarded the contract to me. There was delay in execution of work. Therefore, they took an undertaking that for the remaining work that you are going to execute, we will not pay you the additional cost. Thereafter, after taking this undertaking, there was further delay. Therefore, a supplementary agreement came to be executed between the parties, wherein they agreed that they will pay the additional cost to me or escalated price to me. Now, when we ask for escalated price, they say that earlier you have given an undertaking that you will not claim escalated price. They are relying on 2006 undertaking when they have executed a supplementary agreement in 2008 agreeing to pay the escalated price.
All right.
This is the short dispute before your honors. If I may take my lords to 3 documents in this context. First is my undertaking, page number 138A.
All right. Then next.
Lordship,
are they disputing that you are not given undertaking? Are they disputing that you are not given undertaking?
No.
So where is the requirement for us to go through the undertaking?
Then I may jump to the supplementary agreement that we have executed.
Is there a dispute with regard to execution of supplementary agreement?
They are not mentioning that in their reply. Therefore,
forget about it, sir. Are they disputing that there was no parties were not ad idem on subsequent agreement?
Lordship, there is no word about that.
Then what does Order 8 Rule 6 say?
Of course, then it is an admitted fact that
Section 56 of Evidence Act.
Please,
Order 8 Rule 6, non-traversing the petition averments amounts to admission.
If it is not controverted, it amounts to admission.
That is where you like to take protection and then proceed.
Please, my lord. Lordship, I was relying on this particular MOM only for the purpose to indicate that there was an agreement between the parties for payment of escalation price.
That is your case.
That is my case.
Now that they have not denied,
they have not.
Who has to deny?
Respondent has to.
Whether they have denied?
Not denied.
They have not admitted. Also.
I bow down to this. I bow down. Lordship, thereafter on 31st of December 2010, 156 last clause.
Right, next.
Please, ma'am. They also issued work completion certificate on 31st of December 2010, which is not disputed again. When I requested them thereafter to make payments according to the supplementary agreement, they said that because you have given an undertaking in 2006 that you will not claim escalation price, you are not entitled to it. And the present petition is opposed only on the ground that there is an alternative remedy in form of arbitration. I'll take my lords to the direct judgments of Honorable Supreme Court. In fact, Lordships, in this petition, the claim was with respect to damages for cancellation of contract, which was also awarded by Honorable High Court and which was upheld by Honorable Supreme Court. If I may draw my lord's attention to para 38 onwards. Turn to the supplement. Lordships, what they are claiming is that work got completed in 2010. Then my lords may mark, since 2011 till December 2019, they have never denied my claim for escalation.
What were you doing?
Lordships, I was pursuing with them.
By what?
By continuous correspondence. It is on record.
All right.
Those are on record.
All. Take out 2006 for SCC 322.
In this case, there has to be at least a single denial. I was asserting my right since 2011.
Mr. Counsel, suppose B owes money to A, right? B doesn't pay. So A keeps on writing letter. Nothing is replied. No reply, no admission, no denial. After 15 years, the B replies saying that you are not entitled to, we will not give you, reject, we will not entertain your claim. So you mean to say that is the cause of action for you? It will revive the cause of action?
Lordships, in my respectful submission, I'll endeavor to answer this in the best possible. Lordships, in my respectful submission, the cause of action for me will be the date on which the dispute has arisen between the parties.
So that is what? To keep the list alive, every year once, 1st March or 1st April we'll take it.
Lordships,
1st April you write a letter.
that is not something we have done. In fact, I'll show from
2010 to 2019, what were you doing?
There are continuous requests for release.
Correct, sir. They did not. 1 year they did not, 2 years they did not, 3 years, the 10 years they did not do. So on 11th year, suddenly you got the cause of action.
They denied for the first time on December 2019.
The very fact that they have not replied is denial. If they had given, we are considering, we are examining. If they had said, you are right, there must be some flicker of hope.
Lordships, if my lords may have 2019 correspondence.
How do you revive your dead cause of action from 2010 to 2019? Even an acknowledgement of debt.
No, because acknowledgement has to be within the period of limitation.
Now, can you take at least, if not 8?
Lordships, my respectful submission will be that for me to invoke any remedy under the agreement, there has to be dispute between the parties. That dispute is said to have arisen once there is denial. Otherwise, there is no
Limitation
dispute.
Act says the cause of action, right to sue accrues.
Under Article 137, Lordships.
Wait, your right to sue accrued on the day of your completion of the work.
Please, Lordships, there my respectful submission is that 137 says that right to sue accrues when the cause of action arises. For me, the cause of action is dispute.
Very good, excellent.
And dispute had arisen in December 2019.
Your argument is attractive. Proposition is not.
Lordships, Lordship,
All right.
my endeavor is to.
Please consider. You have tried to make out a case. We agree. That is out there. What is that? That is the endeavor which is required to be made by an advocate. Absolutely, there's nothing wrong.
Please, madam. And Lordship, they also rely on two judgments. One is of.
How? They have already given you, is it?
No, in the reply.